All right, we are back, ladies and gentlemen. Thank you for taking that break. Okay, so we've just finished covering the first section of this, first section of administrative law. Remember, folks, this is a process, okay? We got to go step by step by step. Step number one. The first thing that we have to ask is, one, do we owe this person any procedural fairness? Okay. Do we owe them any procedural fairness? In other words, do we have to care about the person that's standing before us at all? Do we owe them anything at all? That's question number one. Okay. And we talked about where we find that stuff. Remember, we take a look at the enabling statutes. We take a look at the general statutes. We take a look at any secondary applicable statutes. The last place we take a look is the common law. Okay. Common law oftentimes is very confusing. So what did the Supreme Court do? In their infinite wisdom, and I do mean this very complimentarily, in their infinite wisdom, the Supreme Court said, you know what? We look to the night factors. Okay? Remember what the night factors are. Yep. N-I-G-H-T. Okay? That's where the night factors fit into the grand scheme of things, is in question number one. Do we owe this person procedural fairness? Okay, so let's move on. We are now dealing with the second question. Okay? So let's assume that the answer to question number one is in the affirmative. In other words, yes, we owe them some level of procedural fairness. What's the next logical question we're going to be asking? Well, the next logical question we're going to be asking is, how much procedural fairness do we owe them? In other words, do we owe them all the protections and all the content and all the substance of a trial? Or do we owe them just enough so that they get a chance to state their case, and that's pretty much it? Okay? So while we're thinking about question number two, okay, the theme of question number two, I want to make sure that we understand that we're talking about a sliding scale. Okay, it's a sliding scale between an informal hearing, okay, and a formal hearing. Now, let me give you examples of both. An informal hearing would be something along the lines of challenging a parking ticket. Okay, it's about pretty much as informal as you can get. Yes, I have challenged my fair share of parking tickets and lost every single time. It's not my fault. Those meters they're rigged. I swear to God, they're rigged. But hey, that's just me. A formal hearing, on the other hand, which is on the extreme side of the equation, that's more like a trial. Okay, we're talking about a jury or an impartial trier of fact, and then we have lawyers, we have cross-examination, we have evidence admitted, we have rules of evidence, we have all the formalities that are afforded to an individual at a trial. So while we're talking about question number two, I want you to keep this sliding scale in mind, because that is going to dictate how much procedural fairness we owe. Okay? That's what we're talking about. Okay, first and foremost, the question is, do we care about this person? That's question number one. Second question is, well, how much do we care about them? So in other words, number two, how much procedural fairness do we owe the person who is filing the complaint? Okay, how much procedural fairness do we owe? Now, where do you think the first place that we're going to look? Yeah, that's right. If you said the enabling statute, you get the gold star. We always take a look at the enabling statute first. Always, 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 always. Why? Because statutes trump common law. They are the black and white letter of the law. You always take a look at those first. They're not paying me for this, but I love LaCroix water. Yes, I know. Everybody makes fun of me for it. Love it. Love this stuff. So, all right. How much procedural fairness is owed? Okay? We always take a look at the enabling statutes first. Sometimes the enabling statutes are helpful. Sometimes they'll at least give some kind of enabling. Okay. Sometimes they'll give you, well, you know, the individual, or if there's a complaint filed, the hearing must take place. Well, that's at least some kind of guidance. That's at least some kind of help in terms of, well, what are we looking for? What's the procedure here? What's the protocol? Okay. Remember, folks, what we are dealing with is a situation where we genuinely don't know the answer to these questions. So above all else, what is the part of your answer that matters most? Is it the conclusion? Is it the rule of law? Is it the issue spotting? No. The biggest portion of your exam points comes from your analysis. Okay. What does the enabling statute say? Is it applicable in this situation? If not, if we don't find it in the enabling statute, where do we look? Where's the next step? What do you think? That's right. It's not rocket science. You go right down that list. Enabling statutes, then you go to the general provisions. Okay? If it's not there, where do you look after that? You look at any secondary related statutes, if there are any. Finally, we come to common law. And guess what? Common law leads us to the famous or infamous Baker case. In other words, the Baker factors. Okay? Taking a look at the Baker factors is something that I hope that you've noticed. Baker factors, first three of them, guess what? They're very similar to the Knight factors. Okay? We're going to go through the Baker factors in a little bit more detail later on in class here, but I want to make sure that we understand where we're at in the grand scheme of things. Remember, folks, right now what we're doing is just a general outline. This is not an in-depth analysis of absolutely everything. For that, you know, for those playing the home game, please contact us and we'll make arrangements for private tutoring. But for the purposes of these videos, all we're doing is just going through the general outline of things. Okay? Baker factors, are they the last bastion of hope? No, they are not. After the Baker factors, you can also take a look at the Constitution. Yep, Constitution, Section 7, life, liberty, and security of person. If there are constitutional questions or rights involved, chances are the Constitution, or at least the case law, interpreting the Constitution is going to tell you where you're supposed, or how much procedural fairness is owed. And can you guess whether or not you're going to be owed a lot of procedural fairness when you're dealing with the Constitution? Probably. Okay? Remember, the Constitution is the supreme law of Canada. It's the supreme law of the land. So if you've got constitutional issues when you're in administrative law, chances are you're probably going to get a lot of procedural fairness. Remember that sliding scale from informal to formal. Okay? When we're dealing with constitutional issues, you're closer to the formal section of that sliding scale. Okay? If you're dealing with something like, again, parking ticket, or even a speeding ticket for that matter, yes, it does affect you. Yes, it's going to cost you a lot of money. Not that I'm speaking from a lot of experience. Shh, don't tell my wife. But it will lead you to some level of procedural fairness, but nowhere near as much as dealing with a constitutional issue. Okay? The Baker factors tell us how much procedural fairness is owed. The Baker factors tell us where do we fit on this timeline, or on this sliding scale, informal or formal. Okay? The Baker factors are going to tell us where we're going to end up on that sliding scale. Is it closer to the informal or is it closer to the formal? Okay. All right. Well, for those playing the home game, hope you enjoyed this video. Please like and subscribe. Also, more importantly, please contact us for further detailed analysis of administrative law. More coming up, folks. Have a good day.